Okay, so today we are continuing on a theme that you heard a lot from, really from Larry's opening remarks, certainly from Angela's beautiful plenary this morning, and I know has been a theme in some of the workshops and sessions along the way, and very much tying in with what Amelia just referenced with the Alan Detlef book, right? And so we're here to talk about the history of racism in child welfare and how it has shaped not only the sort of federal system of foster care as we know it today, but also the system that exists here within Washington State in some really unique ways. And so I just want to sort of emphasize that we're here talking very much about sort of both national and from a state focus. So we're going to talk about three sort of main things. One is what this resolution, called ABA Resolution 606, you have copies on your table, and then there's additional copies printed on the welcome table in the back. What does it say, and what does it mean? We're also going to talk about why within the resolution and within the presentation today we focus so deeply on looking at the historical roots of racism. And we really are conscientious, right? That we're not talking about like disproportionality, and we're not talking about like disparate impact. We're talking about racism, right? Like we're not talking about, and so we really want to explain sort of through the presentation and through some of the material that we're going to go through why we felt it was so important to go directly into that language and into that focus. And then, with leadership from Ashley and Joyce, and I think Amelia is going to facilitate some discussion as well, we really hope to deliver on helping think through in partnership what you all can do with this information here in Washington State. So this is the quick, background and contact information for anyone to follow up after the fact. Joyce McMillan, founder and executive director of Just Making a Change for Families, and about 1,000 other things that we didn't list on here. Ashley D. Williams, parent attorney based in Los Angeles, and also a member of something called the ABA Commission on Youth at Risk. And then I'm here as the director of the ABA Center on Children and the Law. So really quickly, just to orient you into like what that does mean, if you haven't done work with us in the past at the ABA, the Center on Children and the Law is an organization that's essentially a nonprofit within the much larger ABA. The ABA as a whole is a trade association of lawyers and judges and other legal professionals. We have about 300,000 legal professionals who are part of that association. And then within it, we have this sort of nonprofit called the Center on Children and the Law, where we're funded to do grant projects around the country focused on promoting access to justice for children, for parents, and for families, right? So very much in keeping with what all of you do on a day in and day out basis. As I mentioned, right, we're part of a trade association. So one of the key things about making sure that the work that we do within the center remains deeply connected with the larger membership of the ABA is done through something called the Commission on Youth at Risk. And that's what Ashley's here representing today. The Commission is a member of ABA. It's a body of ABA members who are appointed every year by the ABA president to help design policies and help us pass resolutions, which is what you have, that speak on behalf of the entire association. So why am I giving you that background, which seems really tedious and kind of boring? It's really important for understanding what the significance of this resolution that you have in your hands is. So you can see it up on the screen, and it's in the materials online. But this resolution, as you'll see on the top, this doesn't represent the position of the Center on Children and the Law or the position of the Commission on Youth at Risk. It represents the position of the entire 300,000 ABA members, and it represents the position, frankly, of the legal profession on these issues. And actually, just a month ago, the National Council of Juvenile and Family Court Judges, which represents the position of all juvenile and family court judges across the country, also signed on and adopted this as their own policy. So I just want to sort of underscore the significance of this being a piece of policy that really has significant backing across, business lawyers and litigation attorneys and tax lawyers, et cetera, and judges. Okay, so the main portion of the resolution that I'm going to talk about is this first stanza, which calls on all legal professionals, and again, that's intentional language, right? We're not just calling on legal professionals who are in child welfare. We're calling on all legal professionals to understand and learn about anti-Black systemic racism within the child welfare system, stemming from the history of slavery in the United States and perpetuated by over-surveillance and underinvestment in Black families in America, which is pervasive, ongoing, and a root cause of the disproportionate involvement of Black parents and children within the system, right? So I said before, this is not a presentation about disproportionality and what we do with that. It's a presentation about the racism that has led to what we call disproportionality. And I want to highlight here a couple of other things that are really intentional about the language. Often people in this presentation wonder, like, well, why is it only about Black families? Like, there's obviously, as we heard from some of the introductory remarks as well this morning, related to tribal communities and the development of ICWA. There's been so much different form of discrimination that a lot of different people and populations in our country have experienced that often connect with family law and practice. But this resolution was really specific for a reason. We realized that as an association, as an ABA, we actually had a lot of policies in place already talking about discrimination towards immigrant families, discrimination towards tribal communities and Native American families, discrimination towards people on the basis of gender and sexual orientation. But we did not have anything that was exclusively focused on looking at discrimination toward Black families and specifically the way that Black parent and child relationships have been governed under the law and how that has shaped the system that we have today. So it's very intentional that we went sort of specifically into that focus. Okay, before I get into the actual historical pieces of this presentation, I wanted to orient you as to why we felt it was so important to go there, right? Why did we sort of say we couldn't just put on paper something from the ABA that said we care about these issues and we're going to do better? And I say that this is like my 2.5 answers. So the first one is this Desmond Tutu quote, right? We learn from history that we don't learn from history. So he's one of the architects of truth and reconciliation in South Africa. And I think is such an important reminder that it's really easy for us to try to jump to the reconciliation. And we had that. Remember I told you about this body, this commission, which is comprised of a bunch of different members across the association. A lot of them are not people who are necessarily in our space. And we had a lot of people from different backgrounds, different ethnicities, different cultural backgrounds who said, like, well, why can't we just start talking about the solutions to these issues? Why do we have to go back? Why do we have to learn our history? And I think that if there's sort of nothing else you take from this slide, it's that we don't get that. You're never going to reconcile. You're never going to move forward, right? None of us, together, independently, collectively, we're never going to move forward if we don't go back and understand and truth tell and do that part before the reconciliation can even begin. So that was a big part of why we went back. The other, and this is a slide, it's very rudimentary clip art, you can see it as what you want to see it as, right? Some people see it as demolition, some people see it as construction. When we began conversations about how to tackle a policy within the ABA related to race and racism and child welfare, we realized that it was because part of the reason was because we needed to be a part of conversations that are happening across our country right now, like certainly happening in Washington State, but elsewhere as well, around abolition, right? It's even the title of the book that's on the table, around transformation, around reimagining, around, tearing down, taking apart. And we felt like it wasn't really appropriate to be in those conversations if we didn't know what we were even talking about tearing down, right? So how can you tear an edifice down if you don't know where the studs are? How can you tear something down or figure out the strong parts of it to rebuild from if you haven't looked at the blueprints of how it was designed from the beginning? So that's sort of the second reason, is that we really felt like it was important to go all the way back when talking about anti-Black systemic racism in child welfare. We had to go all the way back to looking at origin stories of how the law in many different periods in history in our country has shaped Black child and parent and family relationships. Okay, those of you who are listening really carefully, you heard me say 2.5 answers. So the 0.5, we were presenting this, as I said, to a body of lawyers and judges and legal professionals, and there was no way that anyone was going to sign on to a resolution that called on all legal professionals in the United States to learn about this history if we didn't do a darn good job of making the case of why it all adds up. So that is the 0.5 that we also really needed to make a case, and we couldn't do that by just jumping in. In 1960, this happened, or in 1974, CAFTA was passed. We really needed to make that case in a way that sort of showcased how everything built together and came together over time. Two final points that I'd like to make on this slide. One is related to that first part of the history, right? People sometimes are surprised to see me up here talking about this history. I've been doing this for 2 years now, and I get that sometimes very openly in remarks. And I just want to highlight, right? This is not Black history that we're talking about, even though we're talking about the way that the law has been shaped around Black family relationships. This is all of our history. And what we're going to dive into in some pretty direct ways is that this is Washington State history. It's also, Illinois history, or DC history, or Maryland history, or Louisiana history, or New York history, or California history. All places I've done this presentation and shown the specific data points and historical context in those jurisdictions and how it all comes together. It's all of our shared history, okay? And I want to say on behalf of the ABA that you guys got a copy that actually includes some of the report. We were very conscientious of acknowledging that too. The ABA is not above any of this history, and we have our own past that we are reconciling and working through in terms of some of the discriminatory periods in history that we're going to talk about today, where the ABA was definitely not on the right side of history. And so I just sort of want to make sure that I'm orienting this as this is a shared experience. We're going through it. I'm going through it individually. It's something that we are all a part of. The final thing I'll say before we go into the slides, some of this is going to be jarring and not easy to listen to or to hear. I ask you, if you do need to step out at any point, obviously that's totally understandable and fine. On the other hand, I do ask, and I know everybody did a great job of this at Angela's presentation this morning, please don't be on your phones. You're going to miss the mark. This thing is not going to work for you. This presentation is not going to make sense for you if you're on your phones or you're distracted. And I know there's a lot of important things going on in everybody's lives, but it really will mean so much more to you, and you'll be able to understand so much more of how the arc of history shapes if you're watching the slides and really engaging along the way. As I said, I've done this presentation a lot over the last 2 years. I give that same request to judges. And so far, people have been really good and really respectful, but it's really not about us as presenters. It's about you and how you're going to engage with the material and absorb it the best that you can. Okay, the two themes, as you saw in that opening sort of description of the opening stanzas of the resolution, two themes that really came out as we were exploring this history, right? Number one, over-surveillance, and number two, underinvestment. Over-surveillance, I feel like we talk about a lot, right? Whether we're talking about criminal law or child welfare. But one of the things that became really clear is how important it is that we raise up and look at the way that laws around underinvestment and very deliberate underinvestment have also facilitated separation between Black families over time. And what I want you to think about as we go through the slides on this historical context, the ways that over time you're going to see these two themes of over-surveillance and underinvestment converge. And here in Washington State, there's a really funky way that they kind of became one at one period in time. Okay, so obviously, as I've already alluded to and you saw in the text of the resolution itself, there's nowhere for us to start if we're talking about the history of Black family separation, Black family regulation, if we don't start of it all, with slavery. And the main thing I like people to take away from this slide, right? I could do an entire day on the material in this slide. I could do a very long session on just this. What I really want everybody to take home, family separation was integral. It was not incidental. So I mentioned, right, I'm from Illinois. I learned about the Civil War and the history of slavery, and I never learned how deeply intertwined family separation was as a crux of the legal and economic system of slavery. What do I mean by that? Okay, the threat of separation was the number one tool used to force compliance. From a parent perspective, it was the scariest thing that could happen to you, was that your children would be taken from you as punishment for you not complying with your circumstances. As a child, we have recorded interviews in the National Archives in DC of individuals who were enslaved as children saying that as young as 4 years old, they understood that they needed to obey because of the risk of being sold away from their parents, their relatives, their siblings, if they did not. Family separation was a tool that was used to force compliance. Second, after 1808, when the transatlantic slave trade, as it had originally existed, was no longer legal in the United States because it had been outlawed. You could no longer import individuals from other countries as enslaved individuals after 1808. What happened? Our population of people who were living in slavery ballooned. How is that possible? The violent act, right, of forced pregnancy and taking children from their parents, primarily their mothers, served the direct economic interests and propelled the ongoing existence of slavery after importation of individuals in enslavement was prohibited in 1808. To bring this piece home, I have this really powerful quote, right, from Thomas Jefferson, who gifted drafter of the Declaration of Independence, also, right, gave this business advice a couple years after he had been president of our country, and a number of years, obviously, after he wrote the Declaration of Independence, gave this business advice to a friend of his who was a plantation owner in Maryland. I consider a woman who brings a child every 2 years as more profitable than the best man on the farm. I like to share this legacy note, right? Because every now and then in the audience I still have people, and maybe here in Washington State, where you're like, well, we're not really connected with all that. Like, that's not our history exactly, right? I like to bring this legacy note to the fore by saying, so I've known my husband since we were 18 and 19 years old, respectively. We met in college. And we reached a point in our relationship when we realized at 36 and 37 that we had known each other for longer than we had not known each other. We didn't celebrate, we didn't do like a big party or anything, but it meant a lot to us because it was kind of this moment of realizing from that day onward we had grown together more as individuals than we ever had before as individuals separate. I will share uniquely today, because I've never done a presentation like this on this particular date. Today is our 18th wedding anniversary, so now it's been way beyond those first 18 years. And Sharonda and Amelia, you mean so much to me that when my husband said, "You're what? You're going to Washington State?" I said, no, it's these two women who are really important. I got to be there. So the reason I share that, knowing him for 18 years and then learning each other, right, and growing together, slavery as an economic and legal institution was a part of this country and the colonies before it for over 250 years. And it has only been illegal in this country since 1865, as Larry mentioned before, for 159 years. We have not known ourselves as a country. We have not known ourselves as a people for nearly as long without this institution as we have with it. And so it makes sense that this continues to shape and cultivate everything that came next. And Washington, I'm sorry, but I gave you the heads up that this was coming. You are not off the hook on this one, right? So one of the things that I like to do when I do these presentations in different jurisdictions is to make sure that I can kind of look at some information that's local. One of the reasons why, and I learned this a couple of years ago, but one of the reasons why there's such a small Black population in Oregon and Washington State is because during the sort of, Oregon Trail period of time and the founding of the Oregon Territory, which included originally what is now Washington State, this was the beginning of redlining. Like, you guys invented it, right? There were laws starting in 1844 and then codified in 1849 that specifically prohibited anyone who was Negro or mulatto from entering into or residing within the limits of the territory, which included Washington State, and there were criminal consequences if you were a Black person who was found to be living here. Also, there were people who were brought here as enslaved individuals, and there are links to this material for anyone who wants to do a little bit of a deeper dive. There were quite a few Confederate sympathizers and supporters of the Democrat. It was the Confederates were the Democrats, the Democrat movement to secede. So this state itself has a really interesting and tangled history when thinking about its relationship with those 250 years. Also, and this was something that I didn't learn until getting ready for this presentation, right? There's 8 counties in Washington. It was 9 because King County was actually named for a slaveholder until it got repurposed and now is named for Martin Luther King. It's a really easy switch. But there's all this ongoing legacy of things that are named here after Confederate leaders, bizarrely enough. Okay, and we're going to get back to that in a little bit later in the presentation. So during Reconstruction, after the abolition of slavery, continuing with this over-surveillance theme, right? Separations between Black children and Black parents continued with great regularity. There were 2 types of laws in particular that took hold, not exclusively in the South, although they were obviously more prominent and pronounced there. One was vagrancy laws, which criminalized unemployed adults, typically parents, right, and returned them to plantation labor, to forced labor, which was allowed under the 13th Amendment. And then this one I really want to make sure that we go deep on. apprenticeship laws. This was a concept that allowed the hiring out of youth, typically black boys, to former slaveholders, with the idea that they were so impoverished in their families that it served their best interests. That's literally the language that's documented by judges who signed off on these apprenticeship arrangements. It served children's best interests to be apprenticed back to a slaveholder, to do forced labor while they learned a trade, rather than grow up with their impoverished parents. Legacy note, right? And I try to really highlight this as well. There's a lot of states that were full of people who were abolitionists, who were pro-emancipation, etc. There's not a lot of states anywhere in this country, Washington, New York, Illinois, otherwise, where there was a lot of advocacy going on about equality, right? Equal investment, equal treatment of individuals of African descent. And this is really key to understanding this transition in this period in time from some of the theme of over-surveillance to the theme of underinvestment. So, beginning in about 1910, there was a concept that began to take place called mother's pensions. And the idea was to provide support, it was all funded through state and local jurisdictions, to provide support to needy children whose mothers had been widowed, and it allowed those mothers, without the breadwinner, right, to maintain what was called a suitable home. There were some mothers who were just considered unfit altogether to receive this kind of public support, right? So what's really interesting is that it was a legal system, and courts, in addition to caseworkers, were the ones who were supposed to decide if someone was worthy and suitable to receive that support. And on a, sounds familiar, 6-month basis, women receiving stipends as suitable home providers had to go back before a court, and the court would evaluate that woman's ongoing worthiness, and if she was not considered suitable after a period of time, she would have to concede unfitness in the court and forfeit public aid. Okay. So there were also certain categories of women who weren't even eligible to be considered suitable for these kinds of mother's pensions. Unmarried mothers, non-white mothers were very rarely supported. This is only 45 years after abolition of slavery. And by 1931, about 20 years in, we have data that shows about 96% of recipients across the country were white, 3% were black, and they were in like a couple of very narrow jurisdictions, and 1% other. This is the Washington state law. You guys had a mother's pension that got launched in 1913. I don't know how well you can read some of the details, but I just want to highlight a couple of the legal provisions, right? Because I said this is governed by laws and courts. So if you see that bullet number 3, the mother must, this is under section 3, which is the juvenile court makes the allowance, right? So the mother's going before the juvenile court. The mother must, in the judgment of the court, be a proper person morally, physically, and mentally for the bringing up of her children. The court may, in its discretion, at any time before the child reaches the age of 15 years, discontinue or modify the allowance. And this is where, remember I said we're going to see some really interesting convergence that happened in Washington state in particular around surveillance and underinvestment. So hold this last section in your head because we're going to come back to it. This is all still, we're just talking about the mother's pensions at this point, but the mother's pensions were supposed to be governed in the same manner as proceedings are instituted and maintained in juvenile court, and the prosecuting attorney shall render all necessary assistance. And then it says the charity commissioner, having knowledge of the facts, which was typically the caseworker, social worker, overseeing the provision of the stipend, shall carefully investigate the merits of every application to the end that this act may be fairly administered and no person granted relief except those who are justly entitled to it. Okay, so we're talking about investigating someone, and a lot of language in here about like, you know, fraud, and someone might not be worthy of it, and all these things. Okay, but also did you notice there was a reference to it should be administered the same way as the juvenile court, so that must mean that there was already a juvenile court statute in place, right? So look there. In 1913, this is what the juvenile court law provided, that children were considered dependent if they were a vagrant, or if their home, the home that they lived in by reason of neglect, cruelty, or depravity of the parents, or on the part of the guardian, et cetera, or for any other reason, it is an unfit place for the child to live. And then later we have language around it being destitute and not a suitable home for that child to live in. So this is all in 1913 in your state law, right? We're saying we're going to provide mothers stipends, but they should be governed in this way that's very similar to findings of dependency. What's interesting is very rarely were children ever found dependent for these reasons, but it was all sort of on the books that these were concepts that allowed people to be found dependent. Okay, so taking it out of Washington State for just a second and going back to national, when the second New Deal passed, right, so everybody knows, right, in our history, we learned like the Great Depression happened, and then obviously the mother's pensions were not cutting it, and there needed to be an infusion of additional support for women caring for their children. The first New Deal, right, was 1933 and all about banks and men, but 2 years later, when that wasn't cutting it, the second New Deal passed with these key provisions. And one thing that I forgot to note earlier is you're probably noticing along the way that I had some language that's bolded in dark black letters. Let me just go back so that I'm not too unfair. Suitable home, conceit unfitness, child's best interest. Okay. Keep those pieces of bold language in mind because we're going to come back to those too. So this concept of dependent child was a child in federal law who was dependent on public assistance. So we have the first codification in federal law of what a dependent child is. It means someone who's receiving support in their home to be taken care of. And the program that was designed in the Children's Bureau in 1935 was actually created to build on that mother's pensions concept, but to actually get rid of all of the discrimination and the stigma that went with it, and to make it available to any woman. It didn't have to be someone who was widowed. It was not going to be exclusive based on race or ethnicity, and it was going to have a lot of oversight from women at the Children's Bureau who had designed it. And really significantly, they designed it so that once someone started receiving a cash stipend to support taking care of their child, they would then also receive as a complement casework services on the back end, right? So you're receiving cash stipend, and during the Depression, there was a recognition that it was really important to have someone helping you find access to work, find access to food banks, find access to housing. And the entire concept that was designed was support that was not stigmatizing. This is going to be federal money with support that's not stigmatizing. It doesn't sound familiar. It didn't sound familiar to me either. That's because that's not what we got. What we ended up getting was actually, in the 11th hour, Congress made a bunch of really significant changes. So before enacting ADC as a part of the second New Deal, Congress eliminated that federal oversight role. So remember, we were going to have a lot of federal oversight, so there couldn't be discrimination. That's gone. Transferred it from the Children's Bureau, where it was going to be run by these women who had designed it really carefully based on models they had already seen in practice. Gone. Gets switched and moved over to the Social Security Administration. Reduced the program from $120 million to $25 million annually, and then they limited it. They said, states, you have total discretion to continue to administer this as you want. Even though it's federal dollars now, you can continue to use your same suitable home criteria. And they removed this requirement to pay at least enough subsistence that was compatible with decency and health. Okay, so what happened? Once enacted, state and local officials had wide discretion to take this new infusion of federal dollars and set eligibility criteria, continue to define suitable homes based on how they saw it best determined, and they assigned caseworkers. Remember, they were supposed to be the complement after you're receiving cash stipend. Flipped completely. Anyone in here who has social work training, I'm sure some of you know this already, right? Instead, the caseworker became the gatekeeper. And your role wasn't the complement on the back to help with access to housing and food and childcare. You were the one deciding on the very front end whether someone was worthy of support at all. Totally changed the concept of casework and social work. And then, right, and this is only 70 years after slavery had become illegal, they made it clear in state and local implementation of these provisions that you could, the states excluded entire categories of workers, right? So most women receiving these benefits were working in some capacity or another. So they said anyone working in domestic, right? Anyone working in domestic work, anyone working in the fields cannot receive this support. And they canceled periods of coverage. Many states canceled periods of coverage when low-wage labor was short, especially during crop seasons, right? I'm sure that happened here. I wasn't able to do a deep dive into all of the provisions that may have happened here in Washington State. I'm not making this up, right? Here's something from 1939, just a couple years into the administration of age-dependent children, from the proceedings of the National Conference of Social Work. The number of Negro cases is few, due to the unanimous feeling on the part of the staff and board that there are more work opportunities for Negro women, and to their intense desire, there, meaning the staff and board, their intense desire not to interfere with local labor conditions. There's no reason why the employable Negro mother should not continue her usual sketchy seasonal labor or indefinite domestic servitude, rather than receive a public assistance grant. Conference of Social Work. But wait a second, we're talking, this is like the 1940s now, NAACP had been founded in 1909. We know that there's lawyers like Thurgood Marshall out there who are doing a lot of great work, challenging all sorts of other things. Weren't these exclusions challenged at this point, right? Discrimination is something that's actually being talked about and addressed. And the answer is yes. There were lots of organizations, right? The Urban League, lots of women and community groups were raising up challenges to this discrimination. What really unhooked the recognition of this as a problem was actually interesting. It was during World War II, there were images of how we were treating children, especially black children, in various jurisdictions around the United States that became public internationally and became really embarrassing for us when we were the vanguards of democracy, fighting fascism and Nazism, and all of a sudden, right, the spotlight at home didn't look so good. And so, with a lot of political pressure, states began expanding who was eligible and who was allowed to be considered suitable to receive public assistance. So we see the numbers start to go up, especially around 1942, 1948, very close alignment with when we were involved in World War II. This is just data from about 16 states, but the caseload of families on ADC, the proportion of non-white families grew at that period of time to about 31%. Okay, and then there's this really big watershed moment. I know a lot of you are lawyers in here. Who's heard of this case, Brown versus Board of Education? Okay. Who's heard of this case in a child welfare presentation? That's a problem. I hadn't either. And I say watershed moment really deliberately because I want everybody, especially after we talked about how it's becoming less discriminatory and more people are eligible, I want you all to think oh, we're turning a good page, right? We're about to get to a really great place. And the answer couldn't be further from the truth. If you think this has been a dark presentation so far, it's going to really get gross in the next couple slides. And I want you to stick with me because it's really important that we all learn this. What does Brown have to do with age-dependent children or child welfare? It has everything to do with the system that we operate today. And I use the term system intentionally, Angela. Thank you for calling that out earlier. In the late 1950s, right, after 1954, you could no longer lawfully segregate schools, states had to figure out different forms of resistance, right? No one's ever heard, right? Every state was welcoming of integration and it all worked really smoothly and it went great, right? No, that's why we have Brown 2, right? There was a lot of resistance. One of the most powerful tools of resistance that states used were suitability laws because those numbers had gone up. You now had a lot of people who were receiving support. And what better way to really, really put the screws on and get people out of your community so that they can't integrate the darn schools? Cut them from that support that they're not counting on. Find people unsuitable. So all of a sudden, in 1954, state after state after state passed new suitability provisions, way more restrictive than they had been before, and they were open about this, right? The idea that this was designed to limit black enrollment by limiting the number of black families in the community was openly said. We have a Mississippi legislator in 1954 who said on the record that this legislation was designed so that when the cutting starts, they will head to Chicago. Can't integrate the schools if people are not living in your community. These laws eliminated public support for parents by deliberately excluding any family found unsuitable or any family found unfit for public benefits. In Louisiana in 1960, they passed a new suitable home rule, which was actually part of what was called the segregation package of laws, most of which did not get passed, but this one did, that in one fell swoop cut 23,000 children from welfare support, from federal public support, all on the basis that those children were considered illegitimate. Happened to be the same year that Ruby Bridges was integrating the public schools. And 95% of those children cut were non-white. Resistance to Brown meant resistance to family, and black families in particular. And the impact was just extraordinary. In Louisiana, Michigan, Georgia, Virginia, Mississippi, Texas, hundreds of thousands of children were cut from public aid, and almost all of them were black or indigenous, and all of them were considered uneligible for public aid because their parents were unfit to receive public assistance. Not unfit to parent, which becomes really, really key to think about. children mostly remained with their parents. The parents were just found unfit to receive public support. Laws in Florida and Tennessee, though, went a step further. And they actually trained those caseworkers, those gatekeepers, right, to tell a parent who had been found unfit to receive public benefits that now, as punishment essentially for having received public benefits to begin with or seeking it when the child is born, now they have to voluntarily release their child to a relative. We're talking about hidden foster care today. This is the origin of hidden foster care. Caseworkers being trained under law to tell someone because they want to continue receiving public benefits or because they are coming forth to seek public benefits, not only do we find you unfit, you now have to release custody of your child, or we're going to refer you to a juvenile court for child neglect. Up until this point, there's very few cases in law in any state, and I've confirmed, and I'll take you there in a second, in Washington State for child neglect. It really wasn't a thing that people were brought before courts on. By 1960, 23 states had a suitable home requirement limiting eligibility for public support. I know Washington's not on there, but I do want to mention that in 1955, somehow there was a new school that was created in the name Robert E. Lee Elementary School in 1955. A lot of schools got these names right after Brown. And the idea, on public record, was that it was designed in that name to honor Southern residents who had relocated here during the Dust Bowl. Again, there's got to be people challenging this, right? None of this could have just been happening. You can't cut 23,000 kids overnight. You can't just do these things. But remember when we talked about how ADC was passed with no teeth, no federal oversight? The federal government had very little way. They'd never said you can't have suitability determinations. They'd in fact said on the record you can. And there'd never been any state that had ever put forward a state plan on aid to dependent children and gotten it rejected. So it was really hard to figure out how to push back on this. In 1960, the federal officials in the Department of Health and Human Services did try. They rejected Louisiana's state plan, the one that had such a dramatic impact in such a short period of time. But the state, and they challenged it on equal protection grounds. But the state countered and said, there's not enough money between state and federal resources. There just isn't enough money. So we need these suitable home provisions because they prevent expenditure on behalf of undeserving families, which harkens back a little bit to that language that we saw in Washington's own mother's pensions, right? The public response, kind of calling Louisiana's bluff on this one, was but children are rarely removed from these homes, so if the home is truly not suitable for money, why should it be suitable for children? It wasn't meant to say children should be removed from these homes. It was meant to call the bluff. But you see where I'm about to go, right? Federal officials ultimately signed off on the state plan because they couldn't do anything else, but they weren't finished. Who here has heard of the Fleming Rule? Yeah, very small number of us. Arthur Fleming, who was the head of what's now HHS, it was HEW at the time, under President Eisenhower, issued this ruling, right, in January 1961. Interestingly, right, January 1961 is when Kennedy was being inaugurated, so it's a little tough to say Fleming was going to do a lot with this rule because he was on his way out. 3 key parts of the Fleming Rule. Number 1, a state plan may not impose an eligibility condition that would deny assistance with respect to a needy child on the basis that the home conditions in which the child lives are unsuitable while the child continues to reside in the home. Slam dunk, right? Finally, on federal record, we're saying you can't do these suitability determinations. But then he includes these 2 really, really sneaky exceptions. And I don't think he meant them to be sneaky, but boy did he solve the wrong problem. If the home is deemed unsuitable, public assistance should either be made to improve the home conditions or make arrangements for the child to live elsewhere. What? No one had been asking for that. No one had ever said, you know what? This discriminatory use of suitable homes to keep black people out of the community so that they don't have to, so they don't integrate our schools. What we should do instead is also make arrangements for someone to live elsewhere. This is crazy. All of a sudden, this comes out of nowhere. Unfortunately, what had been happening in parallel is there was an existing system of foster care that had been run largely through religious organizations and through nonprofits and individual communities across the country that had long sought federal support for helping foster parents provide support to children as they took care of them. And there were organizations like CWLA and others that had advocated for federal support for this. And the federal government had always said, or Congress had always said, no, that's a state's issue. Foster care is purely a state's issue. But all of a sudden, when Fleming includes this exception, for the first time in history, Congress says, and to facilitate this exception, we're going to give states federal money for caring for kids in foster care. And the language that they used was that they're going to pay foster care, right, costs of any child who would have been receiving ADC assistance but for their parents' immoral or negligent behavior. Fleming plus Title 40 foster care funds is our modern day architecture of what we have today. Remember I said we got to take it down to the studs? The studs didn't start in 1961, but that architecture that we've continued to build on sure did. Rather than eliminating discriminatory suitable home limits, Congress incentivized with a ton of money other arrangements exceptions. ADC foster care offered a means of continuing to care for children in theory while continuing to deny support for their unfit parents. And in one swift regulatory and congressional action, remember we've been talking about fitness to receive public aid? All of a sudden that became fitness to parent. You're not fit to receive public assistance became you're not fit to have custody of your child. Federal foster care in 1961 became a massive federal investment in resistance to integration of public schools, facilities, and public aid. And I learned this history, and I thought it wasn't true. And I was like, that can't be, that can't be, that can't be. So before I started doing any writing on this or any presentations, I looked at all sorts of other sources to find the stats, to say, wait a second, like, why did we not know this? Why did these numbers not add up? Before 1960, we were talking about foster care was like this service that was provided through religious organizations, etc. Black children were mostly excluded from that. Very few black children were in anything formally recognized as foster care until about 1961. And before 1960, very few children who were in families seeking aid to dependent children experienced any kind of referral to juvenile court based on parental neglect. Sometimes it happened in Florida and Tennessee, but it was rare because what ended up happening there, right, is that people were so terrorized by that risk they didn't even seek public benefits to begin with. But when the Fleming Rule became law in January 1961, the entire racial identity of children in foster care transformed, and ADC referrals became the primary pipeline of entry into care. By the end of 1961, 25% of all children in foster care were black, and 81% of that number were in care because their parents were deemed unfit, based on being unmarried or living in broken homes. Nothing to do with abuse or harm to that child. The total number of children in foster care increased nationally by about 67% in the span of a year. And there's different data from different sources. Some say this is an underestimate and that there were 150 new cases based on the Fleming Rule. But the bottom line is there was a huge increase when that Fleming Rule plus federal funding that said we'll pay for you to take a child from that family, all of a sudden we created this massive, massive system. By just the mid-1960s, roughly 2/3 of all cases of children going into foster care were from families on AFDC public assistance. It was called AFDC by then. Tens of thousands of black parents lost their children, and black children lost their parents, their kin, and their communities. It's 100 years after the abolition of family separation that had happened with such regularity under slavery. In 1961, poverty, and black poverty in particular, legally became parental neglect. Unfitness to receive public benefits because we do not want to support you in our community became unfitness to be allowed to continue to parent your child based on parental negligence and immoral behavior. There was no evidence base. We talk all the time, I work in a lot of national arenas, right, where it's like, oh, to change mandated reporting, we need more evidence, or to change, providing support on the front end, or prevention, or lawyers, we need more evidence, we got to do like all these studies and get all that evidence. No one provided any evidence ever to say removing children from their home because their parents are poor is going to be a good thing to do. Put another way, and this is one of my favorite sayings, if foster care is a good thing, black children would only get in through affirmative action. It's brutal that Joyce said that 2 years ago, though. I'm going to wrap up in a minute, but I want to bring it back to the legal, and I'm going to bring it back to Washington State. So these numbers, that huge increase, people saw it. People were horrified. Remember I said organizations like CWLA were advocating for the federal government to support people who were taking care of children in foster care long before this. This was not what they'd wanted either. So all of a sudden, everyone sees this huge increase in how this is being used as a even worse discrimination and essentially terror, right, to black families, and pushed not to get rid of the Fleming rule, but to add judicial oversight. Surely if we have the check and balance of judicial oversight, it'll solve this problem. And the language was to ensure that rogue caseworkers would not remove children from their homes simply to punish poor mothers for applying for public benefits in the first place. And I don't have to tell you guys the story, right? Did this work? Not at all. Parents and children lacked counsel, and after court review, it made it even harder to get your kids back because you had a caseworker removal, and then you had it signed off on by a judge. Very little ability to overturn it. The language that Congress passed to codify judicial oversight was in 1962, saying that states could seek maintenance payment reimbursement after removing a child from a home that was, quote, judicially determined to be so unsuitable as to be contrary to the welfare of such child. Nothing in there, again, about abuse or injury or anything, contrary to the welfare. That's all it took, a judge saying it's contrary to this child's welfare to live in that home. I don't know how many of you have checked out the language that's still on the books. This is it. This is what our law says today at the federal level, that each state with an approved plan can get foster care maintenance payments from the federal government when a child has been removed from the home of a relative into foster care. If the child, while in that home, would have met the AFDC eligibility requirement, now you know where that comes from, the removal and foster care placement are in accordance with the voluntary placement agreement, thank you, Florida and Tennessee, or a judicial determination to the effect that continuation in the home from which removed would be contrary to the welfare of the child. And now, as of 1980, we have this addition, and that reasonable efforts have been made. It is the same thing that we got in 1962. Congress added a couple of other things really quickly. Most important is, for the first time, they expanded the amount of money that they provided through ADC, and they started earmarking it for foster care. So $5 million addition for foster care in that first year. It's going to go up to double by 1968 to handle the number of cases going into foster care. And then, in 1962, when they realized that states could not accommodate having 150,000 children removed into foster care, Congress made a second change and said, you can use this foster care maintenance payment funding to pay for a child in an institutional setting. It doesn't have to be a family foster care home. Detention facilities were the massive beneficiary of this, right? Children all of a sudden were removed from their families and placed in congregate and detention facilities as a requirement. Washington State, the word dependent child in 1961, still on the books, right? Or for any other reason is an unfit place for such child. But what's weird, and I'm not going to go into all the details of this, but it's really funky and you guys should explore it further, is in Washington State, your Supreme Court, which has issued some significant decisions recently, some good, some not so good. In 1952, this was the only case I could find that really evaluated those statutes, and they kept the child at home. They said this child should actually go back home because you're comparing foster parents and their ability to financially provide for this child with birth parents, and that's not right. That's not what we do. That's not a viable way to look at the importance of parental rights. But by 1966, and these are cases 66 and 67 that started in the courts, right, in 62, 64, I think, but by the time they got to the state Supreme Court, it was 66 and 67, complete flip of what that language was being interpreted as. That bullet 3, unfit place. Mrs. Todd desperately wants, this was a school referral. This was a case that came up because a school referred the child. Mrs. Todd desperately wants to keep Deborah, but that should not prevent appropriate authority from attempting to ascertain whether the Todd home meets minimal standards under Subdivision 3 for any reason is an unfit place for such child, which permits the juvenile court judge who is sitting in a dependency matter wide discretion and latitude in considering whether a particular home environment is a fit place. Just a year later, a direct juxtaposition. During all these years, the little girls have remained within the stable and harmonious conditions of a suitable foster home. They've got a real tie to the foster parents. And the parents, the natural parents, have been unable to establish a suitable home for the children because they reside in a small 2-bedroom house owned by a relative who also lives with them. The father testified that the main items on the family diet were green soybeans and horse meat, together with fruits and vegetables when in season at low prices. That is unfit and unsuitable for them to be allowed to continue to care for their children when they are living in a harmonious, suitable home elsewhere. Do any of these terms still sound familiar to the laws that you guys implement today? Compliance, best interest, dependent children, casework services, suitable homes, fit, unfit parents, voluntary release, child neglect, immoral or negligent parent, institutional settings, contrary to the welfare, and I will add available, because that one was also on the books in 1961 in Washington State, and I know became really relevant recently here. Understanding the foundation is critical to understanding what came next and where we are today. And I am just about to wrap up, but I want to hit you really hard with this snowball. I do this slide on purpose. It's supposed to feel overwhelming because everything that came after that just grew and grew and grew and grew. In 1962, the Kemp Battered Child Syndrome report called for all medical professionals to report parents for injuries. It's credited with causing that huge increase, but it doesn't work. The numbers don't add up because the huge increase happened before this publication was even released. Also, remember I said 2/3, by the mid-1960s, 2/3 of all entries were from AFDC referrals, not from parental injuries. So that is not the original impetus of an increase in entries into foster care. However, it is where we get mandated reporting, which was originally designed to be for medical professionals only. By 1968, the Supreme Court is recognizing that people are implementing the Fleming Rule in really problematic ways and says, on the record, right, a parent's welfare application cannot justify taking a child, but that same year, Congress authorized another $25 million for taking children. In 1972, Howard and UCLA professors published a book that's no longer in print. Most of these sources are not, titled Children of the Storm, Black Children in American Child Welfare, calling for an end to discrimination against Black families and removal of children in this way. But just 2 years later, Congress passes CAPTA, which builds on that concept of mandated reporting by medical professionals and says now everyone who works with children should report anything that could be abuse or neglect. By 1977, we have 502,000 children in foster care, a more than 300% increase from 1960. And by that time, 75% of all federal funds that were originally from ABC to support families were now being used for foster care. In 1978, the Children's Defense Fund publicly denounced foster care, the entire concept of foster care funding, as encouraging the breakup of families. But by 1981, the federal government spent $300 million on foster care. It transferred to Title IV-E and became an entitlement. And by 1999, more than 567,000 children were in foster care nationally, and close to 40% of all children in foster care were Black. 1960, very few Black children were even allowed to be in foster care. And by 1999, 40% of all children nationally who were in foster care were Black. By 1999, the federal government spent $3 billion on foster care. $5 billion in 2005, $9 billion in 2020. It's around $12 billion now. And Black children still have about a 50%, a little higher, chance of experiencing a child welfare investigation. Should have been highlighted, bolded. When combined with 2+ races, they represent 28% of entries into foster care, and neglect remains the primary basis for entry into foster care nationally. This is a study that came out of California a couple of years ago showing the convergence. You have such a higher likelihood of having your child be referred to child welfare if you receive any form of public benefits today. My final point, going back to the Desmond Tutu quote, on truth and reconciliation. We can't go forward from any of this if we don't start telling the truth. We talk a lot in the national landscape, I'm sure in Washington too, about the importance of investing in concrete and economic supports and preventing the need for foster care, right? But I question what we are even talking about when we say those terms, the need for foster care. The irony is that the entire concept of federal foster care as we created it was largely created to bypass providing concrete and economic supports for certain families to begin with. We're not telling the truth. And when we describe those supports as a solution, but we couch it in terms of preventing the need for foster care or preventing maltreatment, I think we're really furthering this pathology of parenting while poor being bad parenting. We also say a lot, poverty is not neglect, but I think that's not true either. I think in 1961 we really clearly and with direct intention created a concept that poverty is neglect, and we've been funneling a lot of money into that architecture for 60 plus years. So we can keep saying poverty is not neglect, poverty is not neglect, but we keep doing it. And we have laws and financial structures designed to perpetuate that. And maybe it is neglect, our larger social contract anyway. And with that, I will pass it back to Ashley.